Judges of the court.
Hear ye, hear ye, hear ye. All persons having any business before this Court of Appeals, held in and for the State of New York, may now draw near, give their attendance, and they will be heard.
Good afternoon. People versus Mattocks.
Ready for court, please?
You're reserving any time for rebuttal?
Good afternoon. I'll reserve 4 minutes for rebuttal.
You've got it. Go ahead. Proceed.
May it please the court, my name is Brian McCleskey. I represent Appellant Mattocks on this appeal. In 2005, the executive proposed a change to the penal law that would make a Class A misdemeanor to cover bent MetroCard usage. In its memorandum in support, it noted that under the then current law, illegal MetroCard swipers could often only be charged with a non-criminal violation. The legislature declined to do so and instead passed a Class B misdemeanor that specifically covered the activity of unauthorized sale of transportation services using a bent MetroCard. Now, months later, after the legislature determined that a 6-month penalty was the appropriate amount of retribution for this crime, the Manhattan DA shoehorned that very conduct into a Class D felony, creating a 2 to 4 year sentence for the same conduct that was addressed by the legislature.
Well, there are 14 different cards here, right? I mean, they could have conceivably run the sentences consecutively to each other, correct?
They could, and
It could have
with
been
just one
14
caveat.
3-month sentences.
They could, and in particular, they could have charged Mr. Mattocks with 3 counts of unauthorized sale of transportation services based on the alleged 3 transactions that the police saw at the subway terminal.
And run that.
They could have run concurrently, and yes, gone up to a
Consecutively.
year, consecutively, I apologize, gone up to a year and a half, and had there
But
been
where,
more.
where does this say that, where does it say that 165.6 is the exclusive way to prosecute bent MetroCards?
It doesn't, Your Honor, and
Why do you think it's the exclusive way?
Well, I'm not arguing that it's exclusive.
So what, I'm sorry, so what are you arguing?
Well, I'm arguing that it goes to show the legislature and the executive, for that matter's understanding that that other criminal provisions did not apply to this behavior.
It doesn't, the section 170, the definition of written instrument wouldn't cover a MetroCard?
It indeed would. A written instrument would cover a MetroCard. There's no question that a MetroCard is a written instrument. There's no question, indeed, that a MetroCard...
And that's under the forgery section. So I guess what the question is what is it that indicates the legislature wanted to eliminate it from forgery and exclusively make it the misdemeanor offense?
Well, there's no such change going on here. The MetroCard was never... let me just say, the bending of MetroCards, or a bent MetroCard, was never covered under the forgery statute. A MetroCard itself can be a written instrument.
I understand your bent argument. I'm just saying, forget the bending. I'm just trying to determine there's no prosecutorial discretion. It's just exclusively the misdemeanor offense. It can't possibly come under the forgery.
Your Honor, if the MetroCard were actually forged, in other words, if the MetroCard did purport in all respects to be an authentic creation of or fully authorized by its ostensible maker, then indeed it could be prosecuted as a forgery. An example might be a token booth clerk who disconnects the system from the MTA's computer and makes up a bunch of MetroCards.
So your argument is that it's not falsely altered
That's correct,
pursuant to
Your Honor.
176?
That's correct, Your Honor. It's not falsely altered. And
So, but it is, in answer to the judge's question, it is a written instrument under whatever it is, 170.10.4.
Indeed, Your Honor.
And the fact that it's been bent and there's a little crease makes it different? It's no longer a written instrument?
Your Honor, it's not the manner in which it's been bent. Indeed, the statute is fairly exhaustive in all different manners in which an instrument can be altered. It says in the statute, including by obliteration, deletion, or erasure. But what...
In effect, this causes an erasure. an erasure of the information that's contained in the chip.
It
right?
is, Your Honor, but that change is qualified by the remaining language in the statute, so that in its thus altered form, it need purport to be an authentic creation. And
But isn't it authentic looking to the computer that's looking at this bent card?
it isn't, Your Honor, and the people's own expert,
Why not?
Dr. Eastman, testified. The people's own expert testified that if one of the fields has been damaged, i.e. by a bend, the device, the reader, can't determine the true value because it knows that it can only read one of the two fields. So it just says, I don't know. And what it does in that case, actually...
But then the writer gets the benefit of the doubt, right?
It does. The rider gets the benefit of the doubt. The turnstile is programmed to let the rider in, notwithstanding
You get
the
an
fact...
extra ride, right?
To get an extra ride in this case, notwithstanding the fact that the reader can't determine whether the card has value. In other words, the card is invalid on its face, and under longstanding law in New York, a card or a written instrument invalid on its face can't be the subject of forgery. This goes back to People v. Snyder, in which
Well,
a writing...
it's not invalid to the electronic reader, though, because that's still giving an access to the mass transit system.
It is invalid to the reader. The reader is letting the rider in, notwithstanding the fact that it can't determine the value. And it can't be said that the fact that the arm swings open is dispositive of the card's validity. You could instruct a human ticket taker to disregard an ambiguity when it can't tell whether the written instrument is valid or not.
Yeah, but
And
it's not void on its face to the computer, right?
it is void on its face to the computer. The people...
But they're letting the people go in, and they get the ride, right?
They do, notwithstanding the fact that it's void.
You're saying the instructions to the computer are when you see a void one, give them one free ride.
In effect, yes. When you can't determine whether or not the card has value, give them one free ride, but mark the front side of that ticket so that that card can't be given the benefit of the doubt again. In that way, it limits the liability of accidentally giving the benefit of the doubt to someone who may not deserve it. So no one's arguing that this is not a crime, certainly, and we can't get caught up in the fact that bending a MetroCard and obtaining an extra ride certainly is a crime, but it's not the crime of...
But you're analogizing to Snyder.
I am
That this
analogizing to
is,
Snyder. And
quote, void on its face.
that's correct. And Snyder has actually been extended, although not explicitly, in a case called People v. Karatu in the Second Department, where a cable box, which is another type of... It's along the same lines as a MetroCard, where it's an electronic device that is considered to be a written instrument and purports to have value. The cable box, in that case, was found to be a forged instrument where it reported information to the cable company indicating account number and all sorts of valid information. The court found, though, that 54 other boxes in their incomplete form, because they required more programming in order to convey information to the cable company, couldn't be considered forgery since they were in incomplete form. So Snyder is clearly analogous to these electronic forgery
Well,
cases.
let me ask you this. If I had a MetroCard that had no value on it, I had used all the dollar amount on it,
Yes.
and I went to enter the subway and I put it in the reader, what would happen? I haven't bent a corner on it. What would happen?
It would say 0.
It
or,
would pop back out, wouldn't it?
Yeah, well, you slide it and it would say card exhausted.
So the give the rider the benefit of the doubt rule is intended for someone who has accidentally damaged his or her MetroCard.
That's correct.
But isn't what your client did essentially fooling the machine into thinking he was that person?
Well, in a sense, yes, but the fact is that any arguable deception there isn't on the instrument itself. The deception would be implied in presenting...
The difference is whether the damage is accidental or deliberate.
Right, and...
You're saying that doesn't adhere in the document. That's a historical fact.
That's right, and it's right. It's not on the face of the document. In fact, the purpose of the forgery statute is that it's to protect signatures and make negotiable instruments commercially feasible.
Suppose the turnstile's broken.
Yeah.
And your guy's there with his bent MetroCard, and he tries it, and the turnstile's broken, so he waves the guard and says, can I get in with this? What would happen?
Well, the guard may or may not let the person in.
What should the guard do? What's he supposed to do in that situation?
Well, I'm not sure what the protocol is for the MTA, but I could imagine a guard doing either one, either saying, I'm not going to let you in, or saying, well, he's got an armful of groceries, or it looks like he's in a hurry, I'll let him in. It's only $2.
Well, I mean, he looks at it, and it looks, does he see, hey, this is a bent MetroCard, this guy is a crook, or does he see, looks like it's damaged, our policy is to give the damaged guy one free ride?
Well, if the security guard saw the card and saw that it was damaged in some way, I'm not sure what the MTA's policy is in that respect. But certainly, if the card were sort of folded in half with a mind, and not in the way that it's been done in this case, but folded in some other way with a mind to say, well, I'm going to try it through the machine. When it doesn't work, I'm going to show it to the guard and say, I accidentally sat on this. Will you let me through? And if the guard does and lets the person through, we can't say that card that's just been grossly folded in half, not in the way in this case, it becomes a forged instrument.
So you're saying so if I go, if there's no machine and I go to the subway station with a damaged card and succeed in persuading the guard that this was damaged by accident and not deliberately, I've committed theft of services but not forgery.
That's correct, Your Honor. Now, as I was saying, and this court said in People v. Cunningham, there's a purpose behind the forgery statute, and it is to protect those instruments which on their face appear to be fully valid.
They include tokens, public transportation transfers, certificates, or other articles manufactured and designed for use as symbols of value.
Yes, Your Honor. I see my time is up.
Answer the question, John.
There's no doubt that a MetroCard can be an object of forgery. And there's news articles that report in the manner that I described earlier. Also, the ingenious method of running one through an 8-track tape player and recording that information onto a blank 8-track, taping it onto an old MetroCard.
Okay, but your argument is bent on it, doesn't do it.
But a bent is not a forgery.
Okay.
Thank you, Your Honor.
Thank you.
Counselor?
May it please the Court, I'm Gina Mignola for the People. In his example...
Why isn't the more specific statute, the more specific provision of the penal law controlled here?
That's an excellent question, and I did want to talk about the fact that in 2005 the legislature did enact this new statute, but if you look very carefully at the legislative history, you'll see there's absolutely nothing that suggests that the legislature thought that the defendant's conduct could not or should not be prosecuted under the forgery statute.
So why use the forgery in this case instead of the misdemeanor statute?
Well, let me go back to, I think, what's going on in that misdemeanor statute, because I think that has never really been explained. I think that the legislature enacted that new statute because it was looking for an appropriate starter crime. If you look at the bill jacket supplement and the excerpts that appear in the reply brief, what you'll see is that the legislature was specifically concerned with first-time offenders. First-time offenders were being treated too leniently. Typically, overzealous prosecutors were charging them with violations only. And the problem was that there was no record or history of their previous offenses.
Is that what the legislative history said, that this was, or the legislation itself, that this is only geared to first-time offenders? What does it say?
Well, what I'm looking at is the segment in the bill jacket supplement that says, under the current law, these illegal MetroCard swipers are often only charged with non-criminal violations, the penalty for which has proved unsuccessful in deterring this type of illegal activity. Since current violations do not appear on the perpetrator's records, there's no easy way to keep track of repeat offenders.
Did you ever charge people who were multiple offenders who had done it before? Did you ever charge them with just violations in your office?
Well, I'm sure that we may have, I can't speak to that. I don't really know what we've done throughout the history of the office. I think what the legislature might have been getting at here is that if a first offender gets a violation, then there's no record of that
Ms.
charge.
Mignola, I didn't hear that first offender part in your
sorry.
summary. I heard what you said, but when you read it, it seemed to say that violators all violators.
Well,
That first ones, that second ones, all of them are being treated to violations. And it could as easily, unless either you misread it or I misunderstood, it could just as easily have been read to say